Hello, this is David Moore of Equity Advantage, and today we're going to talk about exchanges of second homes. Sort of funny actually, because a couple decades ago my mother-in-law had a beautiful place in the beach in Southern California, and it came time to sell that property. And I said, well, why don't we handle an exchange? Do a transaction. You should do an exchange on that property. And so she talked to her tax people about it. And I said, well, you can't do an exchange on that property. I said, well, why not? And they said, well, it's not an investment. I said, well, what have they done with the property the last few years? That's going to dictate what's been done with it, how it's been treated, and so on and so forth. And the tax people were saying, well, they use it as a second home. I said, they haven't been there in years. So as far as we're concerned, it would be treated as an investment property. He responded, well, it hasn't been rented out. I said, well, that's true, but does something have to be rented out to be considered held for investment? And you got to look back on these things and say, okay, define an investment property, what is or is not an investment property, and look at the treatment and what happens. But obviously there's gray areas there. Well, finally in 2008 we got RevProc 2008-16 that sort of gave us a set of safe harbors that allowed straight up allowed exchanges of second homes. And so these are the guidelines. And for a property to qualify for an exchange, a second home to qualify for an exchange, you have to restrict your personal use to 2 weeks or 10% of the time it's rented for the 2 years preceding disposition and the 2 years after acquisition. So once again, we went from an area where it was sort of gray and you had to look at it and make sure you agreed with your tax people what it is, how it's going to be treated, where you wanted to go with it. And now we've got some framework, safe harbors that allow us the exchange of those properties. But I would also sort of throw it out to you, those of you in the audience, both in tax legal communities and the real estate community, define real property held for investment. So although second home needs to have restricted personal use for that 2 weeks or 10% of the time 2 years preceding and past acquisition, what would be the result of a true conversion to an investment property? How long does a property have to be held to be considered held for investment? And if we look back on that, a few years back we had a court case where somebody exchanged into a property, held it for 4 months, moved into the property, they were audited, taken to court, and the taxpayer actually prevailed in court after a 4-month hold. They argued their intent when they bought the property was to hold it for investment. So once again, you've got to sort of look at it. Most important people in a lot of these transactions, when we're looking at gray areas in the codes, are your tax people. And you want to have good, competent tax people you're paying for an answer, not paying to learn on your behalf. But if you've got a situation where you're sort of pushing lines, if somebody were to ask me how long I'd like to see, oftentimes people come in, they say, well, 2 years is what I've been told I have to hold a property, have it considered held for investment. And I'll ask them where they get that from. They say, well, the code says that. Well, the code talks about 2 years with a related party transaction. But if we're looking at an arm's length disposition or acquisition, there's really no stated black and white minimum hold in that code. If somebody were to push me, I'd tell you a year based upon a couple different factors. One, the break between short and long-term tax rates on assets held for investment. Second, it's been proposed a couple times. So I think if we look at what the government's looked at, what they've proposed historically, I think that would be something that you could defend. But ultimately, it's going to come back down to you and your tax people. Good, competent tax people. Talk to your tax people pre-April 15th. They like to know about these things before it's time to file the paperwork. Take advantage of the professionals in your life. Understand the rules that are there. Understand the rules that aren't there. And by all means, ask the questions. The only dumb question is the one that's not asked. So, hope this has helped. Once again, David Moore, Equity Advantage, 1031exchange.com. Thank you.